No mai haere mai, tēnā koutou, tēnā koutou, tēnā koutou katoa. Welcome to webinar 13 about the conduct outside of New Zealand. Today we're going to do a deep dive into Chapter 10 of the legislation guidelines, which focuses on dealing with conduct, people and things outside of New Zealand. I'm Guy Beatson, Deputy Chair of LDAC and General Manager of the Governance Leadership Centre at the Institute of Directors in New Zealand. I've also got a long background in public policy and translating this into legislation, as well as being an economist rather than a lawyer. And I'm going to facilitate today's webinar. I'd now like to ask the panel to introduce themselves. So firstly, I'll turn to Matthew.
Kia ora koutou. My name is Matthew Smith and I'm an external member of LDAC, and in my day job I'm a barrister at Thornton Chambers here in Wellington, and looking forward to talking with you this morning about conduct outside of New Zealand and Chapter 10 issues in terms of the guidelines.
And now I'd like Dagny to introduce herself, please.
Kia ora koutou, ko Dagny Baldockmans tōku ingoa. I'm the other Deputy Chair of LDAC, and I'm also the Deputy Chief Legal Counsel at the Ministry of Justice, and looking forward to this morning's discussion as well.
So thanks for that, team. In today's webinar, we're going to provide you with a framework you can apply when confronted with cross-border issues, and who you should consult during the policy development legislative design process. That framework comprises identifying whether legislation needs to take into account any current or future cross-border issues connected with its administration, and if so, what is the intended scope of the legislation? That is, when will the legislation apply and decision-making powers be exercised? You should also take into account whether, and as part of that framework, whether special procedural rules are required for civil claims and criminal proceedings arising out of these cross-border issues. And finally, as part of that framework, considering the impact of these cross-border issues on the ability of a regulatory agency to perform its functions. So we're going to explore this topic in two parts. First of all, I'm going to have a discussion with our panel members and explore key aspects of the framework that I've just talked about. And then we'll turn to your questions, which I'm sure there will be many, given the broadness of this topic, and seek to answer as many of those as we can. Now, just a reminder, you can do that using the Q&A button at the top of your screen, and don't wait until the end to ask a question if it occurs to you. When you have a question, just ask it and we'll get to it after the panel discussion. So now let's get into today's webinar. The first theme we're going to work through is identifying cross-border issues. Sometimes they're called conflict of laws. I want to start with Matthew. Why is this topic important? Why are we even talking about this today?
Well, it's a good question, Guy. As we've seen in recent years, disputes about how statutes apply in cross-border situations are becoming much more common. Why is that? Well, there are really a few key reasons. The first is that our legal system is now very heavily statute-based. Areas that used to be governed by common law, so court-made rules and principles, are now regulated by very detailed statutes. That shift in turn means that we're dealing with many more policy-driven rules, which naturally creates tension when those rules are applied across borders. Second, globalization has changed the game. We're dealing with intangible goods and services, companies incorporated in convenient jurisdictions, and communications that nowadays are essentially borderless. Trying to fit all of that into domestic legal frameworks is a real challenge at the best of times. What LDAC is seeing is that there is a lot of uncertainty about how to approach an ever increasingly connected global environment when we're designing and ultimately implementing domestic or New Zealand-based legislation. Now, when courts face these issues, and this is an important context, they tend to take one of two approaches. The first of those approaches is known as the choice of law method, which is the traditional private international law route for resolving matters. And it involves identifying the legal issues, choosing the right connecting factor, which might be the location or nationality of the parties to the proceeding, and applying the law that best fits. Sometimes the statute itself will limit its own reach or territoriality, or a mandatory rule will override it. The other approach is statutory interpretation, and by this approach of the courts, it sees the issue as a matter of reading the statute itself and considering what Parliament's intention was using all of the conventional statutory interpretation tools. Since Parliament can regulate cross-border matters, the argument is that we should focus on the policy goals behind the law rather than getting bogged down in international law mechanics. And an old but a good example of that is the One Box inquiry of the 1990s, where you had a clash between Cook Islands secrecy laws on the one hand and New Zealand's tax laws and the integrity of our tax regime on the other hand. And there, the courts ultimately resolved a conflict between secrecy in Cook Islands law and integrity of New Zealand tax law by interpreting really provisions that enabled the compulsion of information relating to a taxpayer's tax affair to be used in a way which took into account but wasn't determined ultimately by the secrecy provisions in the Cook Islands legislation. And that's an example of really the courts reading to a New Zealand and an overseas statute together and working out as a matter of statutory interpretation a solution that involved giving respect and a role for both statutes. In New Zealand, for better and for worse, our courts haven't been consistent, reflecting that cases are ultimately decided on their facts and the court's view of the interests of justice. And we can see that by way of example in a 2010 decision illustrating one of the first of those approaches I mentioned, where the Supreme Court leaned into the choice of law approach in a case about insurance proceeds using a very technical analysis based on the location of the debt to resolve it. In contrast, in a more recent 2018 Supreme Court decision, the court took a completely different tack, applying employment discrimination law using a pure statutory interpretation approach and rejecting the choice of law or conflict of laws method altogether. So where does that leave us? Fortunately, for present purposes, it's not an either-or situation, as we'll explore in the course of the webinar today. There are ways to reconcile these two approaches and build ultimately a framework that helps to navigate cross-border legal issues much more effectively.
So I suspect, on the basis of what Matthew's just said, Dagny, that the answer to this question has become kind of relatively obvious. But why is it important to identify cross-border issues early in the policy process?
Well, thanks, Guy. And yes, as quite rightly noted, as Matthew has just been talking about, in our increasingly globally connected world, there is a potential for significant disputes to arise in relation to cross-border issues. And it's now sort of increasingly common for legislation to involve some cross-border elements. So the implications of not identifying and addressing those cross-border issues at the design stage include creating significant uncertainty, increasing your litigation risk, and potentially undermining the policy objective that you're trying to achieve. So there are many examples of cross-border matters that you should be trying to think about and address because they could have a significant impact on your legislative design. So bear with me for a couple of minutes. It's a little bit of a laundry list, but some of the things that you might need to think about, or that will be examples of things that should trigger there might be a cross-border issue here, are where you've got, you're selling goods and services across borders. So, obviously this might be online selling, but it could just be normal analog selling as well. You might have issues involving the conduct of overseas parties that affects people in New Zealand. Or you might have the reverse of that, where it's the New Zealand conduct that's affecting people overseas. You might have cases in New Zealand that involve foreign parties, or parties where a lot of the assets are overseas perhaps. Or you might have a New Zealand case where there's some element that involves foreign law or the law in another country. Or there might be a case overseas, or their situations arise overseas where they touch on New Zealand law somehow. You might have issues where you need evidence from another jurisdiction in order to complete or carry out a New Zealand enforcement or court process. You might have something that is regulated by New Zealand law here, but where you want it to be recognised or enforced overseas. And an example that springs to mind here from my own Ministry of Justice context is the issue of enforcing things like suppression orders from court cases, non-publication orders in other jurisdictions. So that's where you've got Google News, for example, reporting on a district court matter where in New Zealand, the defendant's name is suppressed. So you've got to think about issues in terms of, how are we going to be able to try and enforce those orders overseas. We also need to think about the areas where we might need international government coordination or cooperation. You'll need to think broadly about what kind of treaties might already be in place or international obligations that are regulating the cross-border elements of this thing already. And then you'll probably also need to think about overseas criminal acts by New Zealand-linked individuals and businesses in the sort of global regulation sphere. So that's just a small snapshot of things you might need to think about. It's obviously important that you need to think about them early and to try and identify them and work through a policy process to ensure that the legislation that you end up is fit for the purpose and the policy objective that you're trying to achieve.
It's interesting though too. I mean, I guess the watchword on that is not just start early, but make a presumption that actually there might be some cross-border issue in a policy issue you're dealing with, let alone before you get to the legislation. And I guess that raises an interesting question. If I can go back to Matthew, so once you've identified something that fits within that long laundry list of what Dagny's just gone through, once those things have been identified, what steps should officials take then?
Well, when cross-border issues do come up in legislation or the design process for amending or creating new legislation, one of the first things that's really important for us to ask is when exactly does New Zealand law apply, and when can decision makers exercise powers? And to answer those important questions, legislation critically needs to be clear, and it usually does this by using what we call connecting factors. And these, it's kind of really our shorthand for clues that help us to decide whether New Zealand law is relevant in a particular context or circumstance or situation. And some of the common connecting factors that are helpful to bear in mind in thinking about these issues include, did the conduct or event happen in New Zealand? Is the critical property involved located here in New Zealand? Is the transaction itself governed by New Zealand law, or does it have an important New Zealand element? Is the person, which might be a natural person or a legal person like a trust or a company, are they based in New Zealand, or in the case of natural persons, are they New Zealand citizens or permanent residents? Was the person present, resident or domiciled in New Zealand at the time of the relevant event or legal action? And could the consequence of the conduct occur in New Zealand? And did the person or the stakeholders that are subject to a regime that you're designing, should they know that, or ought they to know that? But importantly, it's not just about what makes sense domestically here in New Zealand. International law principles also play a role, and that role is in helping us to decide how far New Zealand law should reach, especially when the conduct or people involved are overseas, or in the case of integrated companies where a parent might be overseas, but the subsidiary that the parent controls is based in New Zealand. Of course, there are practical limits, and even if we say that New Zealand law applies, we still need to be able, in a very practical, pragmatic sense, to enforce New Zealand law. That's why choosing the right connecting factors is so important. It's a balancing act between legal authority, policy intent, and real-world compliance monitoring and enforcement. Keep in mind that the weaker the link between the legislation or proposed legislation and New Zealand's policy interests, the stronger and more explicit the language you'd expect to see in the statute to justify its application to overseas events or actions or persons. This is really a complex area, but getting it right and giving a lot of thought at the outset in the policy design stage to the issues is ultimately crucial. If you require specialist advice, can and should be sought from agencies that include MFAT, the Ministry of Justice, as well as appropriate lawyers specialising in international law and cross-border issues.
Yeah, because it's interesting. If you put together the list that Dagny ran through and the sorts of considerations Matthew's just talked about, getting expert advice does seem to be pretty good advice in all of this. And I guess we're spending a bit of time in terms of this particular theme because it's the most important part of this. If you don't get the starting point right, then actually there's quite a lot of difficulties. But I think, Dagny, there's one key piece of this, which is I guess, at the centre of it. Can you talk more about the presumption against extraterritoriality?
Sure. So that presumption is part of New Zealand law. It's kind of forms the backdrop of how you might think about these issues in some ways. Like other presumptions of statutory interpretation, it's a principle that's meant to assist the court in understanding how a piece of legislation is intended to work. The sort of core of the presumption is a presumption or assumption that Parliament does not intend legislation to have extraterritorial effect unless it expressly says that, or there's something that by necessary implication means that it has to work that way. This presumption has its roots in customary international law, which itself sets limits on how far a country can reach with its own laws. So the core concept is that a country can regulate whatever happens within its own territory. So that's kind of like the heart of it, the idea that generally speaking, countries are regulating for what happens within their borders. But as Matt and you and we've already said this morning, in today's increasingly globalized world, things aren't that simple anymore. Things are happening that cross borders all the time. In terms of the court applying or using that presumption, the question that they'll be asking in terms of whether legislation was intended by Parliament to apply to overseas facts or people or things, that will come back to the connecting factors that Matt was talking about earlier. Is there a strong enough connection to New Zealand to justify applying New Zealand's law? Is there a connecting factor that's sufficiently compelling to justify that application of New Zealand law to foreign facts or parties? The courts will strive to interpret statutes in a way that respects international law while still trying to achieve the policy goals that Parliament intended. So there's a bit of a balancing act going on there. But the thing so this is looking at it from the perspective of what's a court trying to do when it's interpreting a piece of legislation. So for us, when we're thinking about legislative design, it's important to have that principle in the back of our mind, because what we want to think about is how do we want the law to interact with foreign facts. If we're regulating something that crosses borders and we want New Zealand law to apply to that, and we've made sure that there's a clear and reasonable basis for that, we want to spell that out in the legislation. So we want the court to be clear that we do intend New Zealand law to apply in these situations. We don't want to leave the court to rely only on that presumption to try and sort of figure out whether it should or it shouldn't apply. The other thing that we need to be aware of is the idea of international comity. So this is the idea that countries should respect each other's legal systems, and obviously in a connected up global economy and world, we do need to respect each other's boundaries and legal systems. The courts here wouldn't want to apply New Zealand law in a way that interferes with another country's sovereignty or undermines the things that that country is trying to do for itself, especially if you're talking about conduct that didn't happen in New Zealand or didn't cause harm here. So we need to be careful about not overreaching. So you can kind of see how the presumption against extraterritoriality is more than just about geography. It's also about respecting international relationships and avoiding legal conflicts. So the court, when interpreting legislation, is going to be looking for clear signals or statements, preferably express statements in the legislation, that there's a strong connection to New Zealand here and that our law should apply in this situation. The presumption against extraterritoriality, like other presumptions, isn't a fixed rule. It's there to help the court decide what Parliament intended in terms of whether our legislation is going to reach beyond our own borders. But in terms of legislative design considerations, it's something that you are much better off to try and address explicitly in the legislation that you're working on.
But it does rely, as he's talked about that, Dagny, quite a lot on the early stages of the policy process. that connection point you've just talked about and being able to demonstrate that is a policy question, not a legal question in all of those instances. Yeah, sure, it translates into legislation in the end, and that's why legislation design matters. But if you don't have that first piece, then that's actually a bit of a problem. So just to draw the themes out of this together, kind of why we should even think about this stuff and some of the considerations. I think it's fair to say that cross-border legal issues are increasingly common. Globalization and the shift to statute-based law mean legislation now touches on international elements, making it essential to understand how and when New Zealand law applies. Early identification of cross-border issues is critical in the way we've talked about. Spotting these issues early in the policy process helps to avoid uncertainty, litigation, and unintended consequences. It ensures legislation is robust, future-proofed, and aligned with its policy goals. And as Dagny's pointed out, and I think Matthew's drawn this out too, using connecting factors to define where New Zealand law applies is absolutely vital in this. Factors like location of conduct, residency, and where consequences occur help determine jurisdiction. These must be chosen carefully to balance legal authority, policy intent, and enforceability. And it's really interesting in this context how those three things come together in ways that arguably they don't come together in other places. As Dagny's finished off, respect the presumption against extraterritoriality. New Zealand law generally doesn't apply beyond its borders unless it's clearly stated, and the courts are going to look for strong connections to New Zealand and clear legislative intent before applying the laws to foreign facts. And finally, just to reinforce a point that Matthew made at the end of his observations, seek expert advice when you need it. This is really, really complex, and so is the legislation design that goes with it. Don't hesitate to consult MFAT, the Ministry of Justice, or international law experts to ensure your legislation is legally sound and internationally respectful. So that's the kind of why do we need to think about it stuff. How do we think about it? What's the framing? I want to talk now about how we go about this, or what the procedures are that go with this. And we're going to, I'll just direct a couple of questions to one to Matthew and then to Dagny. So the first one around this that I'm really keen to explore is, are special procedural rules required for civil claims with a cross-border element?
So good question, Guy. The answer is that the legislation guidelines provide that generally the existing rules of court procedure for commencing proceedings against someone overseas should apply. So when legislation might lead to civil claims involving overseas parties, it's important to think about how these legal proceedings will actually work. Our existing court rules, so the High Court rules and the District Court rules, already set out when and how you can start proceedings against someone overseas. So if you're designing legislation that departs in any way from those rules, which are ultimately a reflection of good practice and wisdom designed by rules committees that comprise of judges and leading practitioners, you need really good reasons to depart from those rules, especially for cases in the High Court or the District Court where those rules are well established and have very good processes to ensure they are fit for purpose in terms of legal principle, but also workability in practice. Now, if you're creating a new judicial body like a tribunal, and it might need to hear claims involving overseas parties, the legislation should include clear procedural rules, ideally ones that mirror the existing court rules. For Trans-Tasman disputes, we've got the Trans-Tasman Proceedings Act of 2010, which does make it easier to manage cases involving overseas parties. There's helpful guidance that's available through the Ministry of Justice website. Also, if your legislation or proposed legislation will create substantive rights to redress, like the right to claim damages, for example, you need to think about whether those rights might be enforced in foreign courts. Now, if that's likely, avoid tying the jurisdiction too tightly to New Zealand courts. For example, don't define court as only the High Court of New Zealand. That way, a foreign court will still be able to award redress under New Zealand law on orthodox conflict of laws principles. And one last tip, try to avoid giving courts broad discretionary powers to award remedies. And we say that because foreign courts are often reluctant to use another country's discretion-based rules. Their preference is for clear, defined powers.
Yeah, but it's interesting actually. Your observations, Matthew, highlight one other issue for me that I think the audience should take into account, and that is when designing this stuff, not all jurisdictions are the same. And you've highlighted a specialised piece in terms of the trans-Tasman proceedings legislation, which means that Australia in this context is much different in that international context than other jurisdictions. So not all jurisdictions are the same, and that's one of the reasons to seek advice. I guess if I can just turn to you, Dagny, in terms of another angle of this procedures theme, are there any special rules required for criminal proceedings with a cross-border element?
Yes, there are several things to be aware of here, Guy. The sort of default position regarding applicability of New Zealand offences to overseas situations is set out in the Crimes Act. As you as you perhaps could anticipate, it reflects the presumption against extraterritoriality. Essentially, the basic rule is that no act or omission outside of New Zealand is a crime unless there's something specific in the Crimes Act or another act that says that it is. So the general presumption is that only things that happen in New Zealand are crimes under New Zealand law. There's a sort of a gloss on that, though, which is also in the Crimes Act, which provides that if an act or omission that forms part of an offence happens in New Zealand, then the offence itself can be deemed to have happened here, even if the person is not in the country at the time. So those are the sort of default rules for criminal offences. They generally reflect the presumption against extraterritoriality. If you're thinking of departing from those rules, that's quite unusual, and it should only really be done in exceptional circumstances. If you're considering it, then you should really have a strong justification for that position. So it should be clear that the people affected have a meaningful connection to New Zealand, or that the law reflects international standards that the person would be reasonably expected to follow. And your justification and your reasons for wanting to have a criminal offence applied extraterritoriality should be well documented in your policy process. There are some other practical limits to enforcing criminal law across borders. One of them is that our Bill of Rights Act does not allow criminal trials to happen in New Zealand for people who are overseas. Under Section 25E of the Bill of Rights Act, you are guaranteed a right to be present at your trial and to be able to present a defence. So you can't do those things if you're not here. The other thing is that if somebody commits a serious offence in New Zealand and then flees the jurisdiction, there is an option, depending on what our relationship is with the jurisdiction that they've fled to, that they could be extradited, which is a country-to-country transaction. We can request to have them back so that they can stand trial here. Extradition's a whole nother topic. It's quite a complicated area of law, but again, it's something that if you're thinking about how offences operate between jurisdictions, you probably need to have some idea about how that works. New Zealand courts can't prosecute people here for breaches of foreign criminal laws. For a case to proceed here in a New Zealand court, that conduct that happened overseas must also be a criminal offence under New Zealand law. If you're drafting legislation, this is picking up on what you both have already said, that touches on conduct overseas, particularly criminal conduct, then you'll need to consult with both the Ministry of Justice and MFAT's legal division, so they can help you assess whether this is a situation where it's appropriate for New Zealand courts to have jurisdiction and how that might work in practice. And the sort of final thing to think about is enforcement. This can be difficult where there's a cross-border element. You might need evidence to use in a New Zealand court proceeding that's located overseas. So you need some kind of process to obtain that evidence and admit it here. Or the proceeds of a crime, for example, might be held offshore. There are existing tools. There's a piece of legislation called the Mutual Assistance in Criminal Matters Act, or MACMA, that can help us to obtain evidence for use in criminal proceedings. It's a little bit more complicated in civil proceedings. You have to follow a process under the High Court rules, which can be a little bit tricky to navigate. and there's also the Criminal Proceeds Recovery Act, which can help in some situations as well. We do have some specific evidence sharing provisions between New Zealand and Australia that I think is set out in the Evidence Act, and there might be some of that aspect in the Trans-Tasman legislation as well. So you'll need to think about where you'll need to have an understanding of what's in those already existing rules and know whether those are going to work for your situation or whether you need to design some more custom or bespoke rules to augment what you're going to need in your situation. And in some cases, especially where New Zealand and another jurisdiction have a closely aligned regulatory regime, we might need more extensive cooperation, and that's something that we're going to talk about in the next section.
We are indeed. And that enforcement piece and regulation we're going to just pick up just to round out our webinar. Now, I've asked quite a lot of questions of our panel today, and you as the audience have your opportunity too. If you've got a question, please use the Q&A button at the top of the screen, and we'll get to that as soon as we possibly can. But we do want to spend a bit of time just summing up the discussion we've just had about both criminal and civil matters internationally, and then we'll move to enforcement briefly as well. So the critical thing out of what Dagny and Matthew have just talked about in terms of both the criminal and the civil side of this is stick with the existing rules unless there's a really good reason not to. Our High Court and District Court rules already cover how to start proceedings against someone overseas. If your legislation needs to do something different, then there's actually got to be a strong justification. If you're setting up a new tribunal or a judicial body, that needs clear procedural rules for the reasons we've talked about. And ideally, those rules should mirror the existing court processes, especially when overseas parties might be involved. Really important, given what we've talked about this morning, to think globally when creating rights to redress. If the legislation and the associated policy creates rights like claiming damages, considering how those rights might be enforced in foreign courts. And avoid tying them too tightly to New Zealand courts. Keep it flexible, picking up the point that Matthew made. Don't make a reference to the New Zealand High Court, make a reference to courts more broadly. Another thing that comes out of that, and just to finish off, avoid vague discretionary powers. Foreign courts are more likely to apply New Zealand law if the remedies are clearly defined rather than left to broad judicial discretion. Now, I suspect that's probably true in New Zealand as well in terms of legislation design, but especially important in that foreign context. Again, just a reminder, use the Q&A button at the top of your screen to ask any questions you have of the panel. We're going to move briefly, as I said, to enforcement. And I guess the interesting thing, and this is a key part of the guidelines across various pieces, including in Chapter 10, can cross-border issues affect a regulator's ability to do its job, Matthew?
The short answer is yes, for reasons that I'll just elaborate on briefly. An important question to ask during the legislative design stage is just that: will cross-border issues make it harder for a regulatory agency to carry out the functions that you're planning to confer on it or add to it if it's an existing agency? If the answer to that question is yes, then the legislation does need to explicitly or clearly authorise cooperation with overseas counterparts of the agency. This is particularly important when regulators need to share information or coordinate investigations across borders. Generally, New Zealand regulators can only use their powers within New Zealand and in relation to New Zealand laws. But when cross-border conduct is involved, that limitation can really affect in practice their ability as regulators to act effectively and ultimately give effect to the policy and objects of the regime that they exist to support and enforce. For criminal matters, MACMA, so the Mutual Assistance and Criminal Matters Act, provides a basic framework for international cooperation. But if you're dealing with civil regulatory action, or if MACMA does not go far enough in the circumstances, the legislation that you're designing should include specific powers that will enable the New Zealand regulator to request help from overseas regulators and vice versa.
It's a really interesting reminder, right? I think sometimes when we're doing both policy and the legislation design, we make an assumption we're starting from scratch. And I think part of this conversation this morning reinforced the fact there's a whole bunch of machinery there that you need to be fully aware of as you're working through this in a policy sense, but also then getting to legislation design. I guess the flip side of what Matthew's talked about, Dagny, is what happens internally in New Zealand. And I guess the question and some things that some of the folk on our call today and others who are viewing this later will be confronted with whether or not New Zealand should recognise or enforce overseas decisions. How do we think about that, Dagny?
Well, again, it's not a one-size-fits-all thing. It's going to depend very much on your particular context and what you're trying to achieve. So sometimes recognising decisions or orders that are made in another jurisdiction is actually going to be quite essential to making your particular piece of legislation work. This might be particularly if it helps to reduce compliance costs here, or it helps to reduce legal uncertainty, or perhaps it prevents people from forum shopping to kind of find the place where they get the best regulatory treatment. It also can strengthen the integrity of a regime by making it effective across borders. New Zealand, and again, the importance of understanding what's already in place. New Zealand law already recognises some overseas decisions, particularly those affecting personal status like marriage, and some civil judgments under common law. And there are some statutory regimes that help. So the Trans-Tasman Proceedings Act is one of those, and it covers a wide range of Australian decisions. There's also an older act called the Reciprocal Enforcement of Judgments Act, which dates from 1934, and it applies to some foreign court decisions. I don't actually know whether that's got a lot of practical application in most contexts, but it does exist. And as we've touched on MACMA several times this morning already, and it allows for limited recognition of some orders in the criminal jurisdiction. Another thing that's worth keeping in mind is that New Zealand legislation can't unilaterally force other countries to recognise New Zealand decisions. In order to have our court decisions recognised in another jurisdiction formally, that requires a bilateral agreement, such as the Trans-Tasman Mutual Recognition Arrangement. And so the other country has to do something to implement it into its own domestic law for that to happen. So the short point here is that if recognition or enforcement of overseas decisions here supports your policy goals, is going to make your legislation more effective, then it's worth thinking about how to include that in your legislation.
That's great, Doug, and thanks, Matthew, too. And I do think there are sort of a few key themes that come out of this. One is cross-border challenges can limit at what New Zealand regulators can do, so you need to plan for that. That's probably not, it should be obvious, but not necessarily. To the extent there's cooperation, and Doug's touched on some of this as well, make that explicit rather than just presume it's going to happen. Thirdly, don't rely on criminal frameworks like the MACMA. I mean, it's useful for criminal cases, but civil regulatory action often needs to be tailored, have tailored powers for cross-border collaboration. And finally, recognition of overseas decisions can make the regime stronger. If you're recognising or enforcing foreign decisions, it helps reduce costs, avoid legal uncertainty, or improve compliance. And it's worth including in the legislation. But just remember, New Zealand can't enforce or can't force other countries to reciprocate without formal agreements. And the panel's touched on some of those today. So before we get to questions, let me just pull this all together. The key thing is starting with what we've got and build thoughtfully from the existing base. New Zealand's existing court rules already cover how to handle overseas parties, so stick with those unless there's a compelling reason to depart from them. If you're creating a new tribunal or a judicial body, make sure its procedures are clear and consistent with the existing frameworks. Second sort of theme to come out of this is think globally and act clearly. That's a variation on that kind of hoary chestnut at some level that we've all heard before. So whether it's creating rights to redress or enabling regulatory action, consider how your legislation will operate across borders. Avoid vague discretionary powers and make cooperation with overseas regulators explicit, especially for civil matters. And tailor your approach beyond criminal frameworks like MACMA when you need it. Thirdly, plan for recognition and enforcement. And I think in that context, that goes to the heart of what we've talked about this morning in terms of just an increasingly global world, an increasingly digital world. So if you're recognising overseas decisions support your policy goals, like compliance costs or improving enforcement, include that in the legislation. Just remember, reciprocity is not automatic. This doesn't happen just by accident. It often requires formal agreements, and always keep the presumption against extraterritoriality, much as it's a guideline rather than a hard and fast rule in mind, unless you've got a strong legal basis to override it. Now, we've got some questions from our audience, so let's move to those. Let's deal with the first one. What powers should regulators have for cross-border cooperation and recognition of foreign decisions? I'll throw that to Matthew and see what he says about that, given the conversation we've had about regulators.
Well, it's probably going to be an unsatisfactory answer, in part at least. And really, it will depend on what you're trying to achieve for the regulator. The other overseas regulators that you're aware of that exist, and if there are foreign actors that are in particular jurisdictions, what those regulators are, and just having a sense of their role and functions and powers. So that's your first really policy design question of what is the nature of the regulation that you're looking to apply in light of where you know or anticipate that it might have a reach. What are the regulators that are over there, and in light of that, what are the mechanisms that are fit for purpose for facilitating and enabling cross-border cooperation and recognition of foreign decisions? And those will always be discrete or bespoke or particular questions to the regulatory environment that you're looking to stand up or to extend, as the case might be. In general terms, what we would do if we were providing advice at a policy design stage in a subcommittee is to identify any similar regimes that exist and are reflected in statutes, and discuss with you what the pros and cons and thinking behind those approaches are. And that's one, because there is good learning already reflected in the statute book on how to design for this. But two is that generally the statute book should be consistent and coherent as a whole. So where we've taken time in the past with PCO and others that are really instrumental in legislative stewardship and design to stand up a regime that is fit for purpose and works, we look naturally to the lessons from that and to replicate that where it's appropriate. So those are my general responses and observations on that.
And I think that provides a way through it, right? In terms of a few checklists and being prepared if you come to an LDAC subcommittee, the sorts of things you're likely to find. I want to move on to Dagny with another. This is always going to be a broad webinar given its scope, but I think there's an important piece in here. The question is, in terms of legislative design, how should you best approach New Zealand Bill of Rights Act considerations for conduct, either with a cross-border element or where the regime applies to situations that can occur in New Zealand or overseas? So I'll throw that to you, Dagny, in terms of how we might think about that.
What a great question. I think that really you should be approaching BORA considerations in the same way that you would for construction of any domestic offence. So I think that you'd be looking to try and make sure that your the offence provision itself is as BORA consistent as it can be. I mean, BORA itself is based on the ICCPR, so it should, its roots are in international instruments which have a kind of universal human rights dimension to them. So we should be sort of striving for this kind of level of international rights consistency. And I wonder if perhaps the person asking the question is thinking in terms of maybe if we're obtaining evidence from overseas to use in New Zealand proceedings, do we worry about whether that evidence has been obtained properly in terms of BORA considerations in New Zealand? And I would think that yes, we would still be concerned about that. So we would be wanting to try and make sure that our process was as BORA consistent with our own internal standards as possible, because that's the court that it's going to be heard in, and we don't want to then open ourselves up to arguments and challenges that the evidence that we're using is inadmissible because it was obtained from a jurisdiction where the BORA protections or the rights protections were not as good as what we have here. So yeah, I think that would be the sort of overall approach, is to try and lift everything up to the standard of New Zealand rights protections if we're going to be applying New Zealand law to the situation.
Yeah, raised an interesting question. I was just thinking as you were talking, Doug, if you think about a jurisdiction like the US, which already has a Bill of Rights built into their constitution, essentially, and it's not identical to the Bill of Rights Act for sure, but it has similar kinds of presumptions. There are other jurisdictions where that's true. So actually just thinking through in a context by context and in jurisdiction by jurisdiction basis actually matters a lot in terms of what you've talked about too. So but yeah, the key thing, and I think the key message out of what you said, is that we should be seeking to see the Bill of Rights Act requirements actually fulfilled in anything happening extraterritorially, simply because that stuff has to happen in New Zealand. Hey, Matthew, in terms of your practice, I'm sure that you're confronting all the time, and your colleagues are too, significant changes in technology and so on and so forth. So I thought I just might throw this one to you. The speed at which technology is advancing, increasingly making it difficult to fit within legislation, which is moving much slower than that. It's particularly true in a cross-border context, and Dagny's touched on this a little bit too. Got any comment or tips for legislative design about how to manage those considerations? And I guess you could look at that domestically, but let's put it in an an international context.
A really interesting and topical issue there. One of the ways to respond to that is where there are countries that might be grappling with issues ahead of us, to reach out and learn lessons from them. And I have in mind, I was in a subcommittee meeting yesterday, and one of the issues there is being grappled with in the US, including in quite recent and high-profile US court decisions. And they are providing answers which are sensible to an evolving policy problem based on accessibility of harmful information on the internet and the ability to convert that harmful information into items that we wouldn't want to have in New Zealand. And so as part of the policy making and design process, it's looking abroad to see how others are grappling or have grappled with the issues, and to try and reflect and build in those lessons as and where they're appropriate. So that's one way to address it. A second way, and something that we'll always emphasise for LDAC, is to think really carefully about the policy and objects of the regulatory framework that you're looking to develop, and spend time working out what your purpose clause is in particular, and how you reflect the purpose, the policy and object of the legislation within the statute itself. And I say that because we're evolving issues get before the courts, and the courts' dilemma is how to interpret a statute that was designed in a world which didn't include an emerging technology or some other issue that's evolved since. The courts have some flexibility to make the statute fit for purpose in a changing world through what's referred to as purposive statutory interpretation, or sometimes referred to as the ambulatory approach to interpretation. And the idea is that we don't want, as a matter of public policy or constitutional integrity, to have statutes that languish in the statute book because they've got moribund and become out of date to the world in which they're regulating. So the courts will strive to give them a practical and purposive interpretation to address evolving matters. But the key to giving the courts the flexibility and discretion to ultimately be able to do that in a fit for purpose and workable way is to ensure that you really spend that time at the front end to get the purpose right, and to reflect that purpose and the policy and object within the statutory structure and scheme and text to enable the courts to apply the statute across time in a purposive and ambulatory way, as new issues will inevitably arise, and with ever greater speed, really, with the fast-changing, globalized, and really the information age driven by the internet that we're living in at the moment.
Yeah, I mean, I guess what you said though goes to the heart of being really clear about what the intent is, and in some cases what harm might be being experienced, and be relatively technologically or technology neutral to the extent that's possible, and recognise for the audience that that's not always possible. Dagny, I want to turn to you because I think there's and I have a bit of an answer to this, but I'm going to go to you first. Are there any instances of other countries updating their laws and consequently requiring New Zealand to update theirs in relation to cross-border issues when New Zealand's made law to deal specifically with cross-border issues?
I can't think of any specific examples of this, but I mean, it would certainly be possible, I think, to have some sort of arrangement where you have a mutual understanding between jurisdictions that you're kind of working on something together, and that if one updates the law, then the other will, use its best endeavours or whatever to do similarly. But I would have thought that would be the realm of diplomacy and, sort of international agreement rather than a strictly legal matter.
Yeah, I think that's right. And
I think it's an MFAT thing,
yeah. But at another level, if you looked at something like the Trans-Tasman Mutual Recognition Arrangement, which allows New Zealand Australian produced goods to be just sold in New Zealand as of right, and vice versa, the presumption there is not about requiring updating of law. The presumption is that there's enough commonality in the approaches and physiology, all sorts, safety and the like, that will work. And if it gets out of kilter, then you end up with all sorts of other issues. And I suspect if you look at some of the changes in immigration policy and the immigration legislation between New Zealand and Australia, that may well be an example of that, where different decisions have been taken by Australia in relation to that than they did previously. And that hasn't required updating New Zealand law, but it's certainly seen changes in their law.
And there's a sort of a concept that you come across in the extradition sphere, I'm aware of it, and maybe in other areas as well, where, when we have other jurisdictions that we work with closely, or that we're sort of, we're willing to surrender people in terms of criminal offences with, that we're looking for things where their legal system is similar to ours, or the offences are of a similar character. And so there's this kind of idea of equivalency. And so I think that's probably a principle that would apply in the sort of thing that you're talking about, that sort of easy interchangeability is something that's appropriate where there's a general equivalency in our law between us and another jurisdiction, but that you wouldn't see that happening where that equivalency wasn't there.
Yeah, no, I think that's right. My slightly funny example, in a black kind of way, was working on the Environmental Cooperation Agreement with the Chinese in 2014 or so, and finding that in a visit to China that the Chinese federal government at least had picked up New Zealand's hazardous substance and new organisms legislation, translated into Chinese, and passed it. Now that didn't then result in them expecting changes in New Zealand law, but I was a bit startled by that. In the time we've got remaining, we'll take a couple more questions. Matthew, in terms of the criminal side of things, and you touched on that in your remarks, could you be present at your criminal trial if you attended via video conference from overseas and the defendant had agreed? The presumption is that would only work in a prison context, was not a potential, if prison wasn't a potential penalty. But could you do it in other cases? What's your view of that in terms of all of this?
There's probably two dimensions to it. In terms of the New Zealand dimension, it will be a question of whether or not there had been compliance with the Bill of Rights Act as it was reflected within the statutory regime. So there's kind of the pure BORA question of whether or not that would infringe any of the BORA guarantees. And it's a question of law, which I don't know that case law well enough to venture any opinion on sensibly at this time. But then there'd be the legislative question of what is the if you've provided powers within a particular statutory regime, with how are those powers able to be exercised? And it might be that in designing those powers, you've given and you'd expect consideration to be given to the border rights that are implicated in the potential exercise of those powers as part of the legislative design process. And if that's done properly, you might well either build in those protections as they most liberally are understood to apply, or it might be a case where there is a Section 5 justified limitation to the pure application of those border rights that then is reflected within the statutory text and scheme that provides your answer. So it will probably be a question of whether or not that is permitted expressly or by necessary implication by the statute, interpreting it consistently where possible with the Bill of Rights in terms of the interpretive obligation in Section 6 of the Bill of Rights Act.
Yeah, and then look at it in that wider context. Hey, we've got time for one last question. I was going to direct to Dagny, and I think it's really interesting because it goes to part of the conversation we're having before. So if we're considering the benefit of exercising a regulatory function or power overseas, should we only take it forward if we would be comfortable with the overseas jurisdiction exercising the same function and power here?
I'm not sure that question can be answered in the abstract, because it would depend on the context. Yeah, I mean, if we're sort of into some mutual recognition arrangement and that's part of what you're trying to do, then maybe that would be a consideration, but otherwise potentially not.
Well, you could turn it around the other way, right? When to the extent that, and the US is notorious for this, at a level of extraterritoriality in someone else's law, does that necessarily mean that New Zealand law should reciprocate?
We should reciprocate. I would say no, it doesn't.
Well, exactly.
Yeah.
So then that comes back. That's less a question of law. That's a question of public policy, and as you were touching on before, the diplomacy piece of it.
Yeah.
And in the end, I guess New Zealand law is about the impact on New Zealanders or people or conduct of New Zealanders potentially overseas. It goes back to that extraterritoriality presumption, but it also goes to the heart of where the benefit and the harm is.
Yes, and what is your policy objective? But in a sense, this question, though, touches on something that's come up many times, is that the legal aspects of this are only a part of the puzzle. There's the whole international law comity, international relationships, that's part of the picture as well.
Well, and I guess the conversation we've had and the questions we've worked our way through this morning just point to the level of complexity and the need to start early to get behind some of these things.
Yeah.
And indeed, some of those questions actually start to highlight the complexity of trying to understand other jurisdictions' legislation, legislative schemes too. And their their policy, what they're trying to achieve, the level of cooperation and the other stuff that you touched on before. So I think that's kind of interesting. So we've come to the end, but I want to thank everyone for attending. I think the discussion today has provided a good overview of the Chapter 10 and of the guidelines. And this includes introducing you to a framework with some key elements, and that includes identifying whether legislation needs to take into account any current or future cross-border issues connected with that legislation's administration. And if it does, what is the intended scope of the legislation? That means thinking about when will the legislation apply and decision-making powers and how will they be exercised. You also need to think about and just reinforce this, whether special procedural rules are required for civil claims and criminal proceedings arising out of these cross-border issues. And noting the point that Matthew made about the fact that there's existing rules, and also the point Dagny made more broadly that says there's a range of precedent that needs to be taken into account. Need also to take into account the impact of the cross-border issues on the ability of regulatory agencies to perform its functions. Matthew's made the really good point in his remarks that actually this may change the nature of what a regulator does, and in some cases, international impacts may impact on what a regulator's powers are too. So it's worth noting a couple of things. There is potentially an international element of every policy issue and decision that you're considering, and that translates into legislation. And secondly, the impact varies by the context and between jurisdictions. So let me point to a couple of bottom lines. Be alive to these issues. Review Chapter 10. Seek advice, including from MPAT and the Ministry of Justice, or some sort of external legal advisor, and consider these issues as early as you possibly can. So finally, thanks for being with us. Thank you to the panel, to Dagny and to Matthew.